UK Immigration Changes 2023, Impact on Student, EU Settlement Scheme, and Skilled Working Visa Categories from July. Greetings, dear viewers, welcome back to our channel. Today, we have some important updates to share regarding recent changes in the UK's immigration rules. On July 17, 2023, the Home Office published a statement of changes in immigration rules, and we're here to summarize some of the key points that are likely to be of interest to both employers and immigrants. Let's dive right in. Let's start by discussing the student-related changes that have been implemented. Student-related changes. The recent reforms have brought significant changes to switching from a student visa to work routes within the country, as well as regulations related to students being accompanied by dependents. Starting from 1500 hours British Summer Time, BST, on July 17, 2023, students are now only allowed to switch into work routes, such as the skilled worker, global business mobility, global talent, scale-up, government-authorized exchange, and creative worker routes, under certain conditions. The conditions for switching to work routes are as follows. 1. The student must have completed the course of study they are sponsored for. 2. If the student is studying a degree level or higher course, their certificate of sponsorship must show a start date no earlier than their course completion date. 3. For doctoral students, their certificate of sponsorship course must show a start date no earlier than 24 months after the start of the research course. Similar requirements must also be met by students who wish to switch to being a dependent partner of someone already on a work route. This change recognizes that the rules on student dependents are already quite restrictive, and it may be more logistically difficult for partners to transition into a work route in country if they haven't completed their course. For doctoral students, caseworkers will use the course start date listed on their confirmation of acceptance (CAS) for studies to check eligibility. However, the Home Office does have the discretion to waive switching criteria outside the rules, but this is usually reserved for exceptional circumstances. The new student switching policy aims at reducing net migration, but it has raised concerns about increased international travel costs and potential environmental impact. Let's now move on to the new restrictions on student dependents. New restrictions on student dependents as announced earlier, starting from January 1, 2024, with exceptions for government-sponsored students and children born in the UK, dependents will only be allowed if the student is on a doctoral course or is enrolled in a research-based higher degree program confirmed by the sponsor. The definition of a research-based higher degree has been added to the immigration rules, meaning a postgraduate program with a larger research component than taught modules. As a result of these changes, taught master students will no longer be eligible to be accompanied by dependents. These changes have already been incorporated into the immigration rules as of 1500 hours on July 17, 2023, but they will only apply to the dependents of students whose course starts on or after January 1, 2024. It is important to note that partners and minor children excluded as dependents under the student route will also be ineligible for the graduate route. This, combined with the planned application fee increases, may lead more students to consider sponsorship under the skilled worker route after their studies. The timing of these changes is significant as immigration rule changes are typically published at least 21 days before implementation. However, these student-related changes were made with immediate effect to avoid a surge of applications. Now, let us talk about the skilled worker-related changes. Shortage Occupation List Update effective from the 7th of August 2023. The Shortage Occupation List, SOL, has undergone expansion, encompassing immigration applications submitted on or after this date. In particular, the following construction industry occupations have been added to the list. 1. Bricklayers and masons. 2. Roofers, roof tilers, and slaters. 3. Carpenters and joiners. 4. Construction and building trades. Not elsewhere classified. 5. Plasterers, including dry liners classified as plasterers for sponsorship eligibility. Additionally, 2 occupations in the fishing industry have been included. 1. Agriculture and fishing trades not elsewhere classified, limited to fishing industry roles only. 2. Fishing and other elementary agriculture occupations not elsewhere classified, limited to deckhands working on fishing vessels 9 meters or more in length, with at least 3 years full-time deckhand experience gained lawfully. It should also be noted that the Migration Advisory Committee, MAC, is presently conducting a comprehensive review of the shortage occupation list. Their report is expected to be published in autumn 2023. Subsequently, the Home Office will consider the recommendations made by the MAC, and updates to the shortage occupation list are likely to occur in either autumn 2023 or spring 2024. Next up, let's talk about general practitioners, GPs, undergoing specialty training. They will now be granted immigration permission expiring 4 months after the end date of their certificate of sponsorship. This provision allows them sufficient time to obtain further immigration permission as a GP with a licensed sponsor. Automatic extension of pre-settled status. Now, moving on to the EU settlement scheme, we have some important changes that took effect on the 9th of August 2023. One significant change is the automatic extension of pre-settled status without the need for a valid application. This change comes as a response to the successful legal challenge presented by the Independent Monitoring Authority. Individuals with pre-settled status, who haven't applied for settled status, will receive an automatic 2-year extension. They will be notified directly, and their digital status will be updated, allowing them to demonstrate their rights to an employer through an online right-to-work check. Please note that there is currently no confirmation about whether visa nationals holding pre-settled status as family members of EEA or Swiss nationals will automatically receive a new physical biometric residence card confirming their extended permission. It might be necessary for them to apply to continue proving their immigration permission while traveling to the UK. Proposed settlement conversion process. The Home Office intends to implement a process to automatically convert pre-settled status to settled status for those eligible. The proposed settlement conversion process will involve automated checks, which might include HMRC and DWP records, as well as passenger name record data to verify international travel history. However, the consequences for individuals assessed to have broken the continuity of their UK residence, and thus rendered ineligible for settled status, have not been fully clarified yet. Employers may be affected if individuals need to regularize their status or leave the UK, possibly necessitating sponsorship or recruitment of replacement workers. I hope this information helps you, and if you're interested in more details or further guidance, let me know in the comments section and I'll be happy to provide more information. Remember to show your support by liking the video and sharing it with others who might benefit. Also, don't forget to subscribe to the channel for more content. Thank you for watching.